Thank you, Mr. Chairman. I would first note the irony of a hearing that's about a fair and equitable decision-making process that has 4 people on one side of the question and 1 on the other. Mr. Dauschman, I do appreciate your efforts. Let me start with Chairman Schomburg. If I might. I noticed that you, Mr. Chairman, you characterized the current board majority's feeling unconstrained by the limits of the law in its recent decisions and behavior. The present board, with its present majority, has achieved unanimity in 83% of its decisions. What was the percentage of unanimity in the board that you chaired?
90%.
I beg to differ. I think it was 67%.
I was not chairman, Congressman, at the time. That was prior to my chairmanship.
Well,
Chairman Lehman and I agreed on 90% of cases.
Excuse me. During the board tenure, where we most recently had Bush appointees as a majority, it was 67%. Now, do you think that's evidence that that board majority felt unconstrained by the limits of the law?
We're talking about 2 different things, and it's like I think you're trying to draw conclusions which are probably not appropriate.
No, I'm trying to state facts that you're claiming that this board is unconstrained by the limits of the law, yet a huge percent of its decisions are unanimous.
There's a routine.
But the board with the Bush majority had a smaller percentage of unanimous decisions. Were they unconstrained in making all these controversial decisions?
When you're talking about 80%, Congressman, you're talking about routine, relatively minor cases. You're not talking about the major cases, which change many decades of board law. The board, for example, decided one case with regard to coercive secondary picketing, in which it adopted a standard which is plainly inconsistent with the language of the statute.
I just don't think that, frankly, the record fits your characterization. You also describe the present situation as a radical manipulation of the board's election process. One of the provisions in the proposed rule is that within 7 days of the notice, the election has to be called. Isn't that right?
No.
Well, sure it is. What does the best practices call for right now under the board?
It calls for a hearing to be scheduled 7 to 14 days, in some regional directors extended.
So do you think it's a radical departure to go from 7 to 14?
Yes, because what must happen, that is a very, very short period of time. They're reducing it to 7 days, they're making an adversarial proceeding, and they're telling the employer it must identify every issue and must file a statement of position.
Chairman,
all of that is different.
Chairman, the best practices manual presently says it has to be between 7 and 14 days. What's a radical difference between 7 and 14 and 7?
If you're talking simply about the time, there isn't. If you're talking about what must happen in that time, there is.
Well, what must happen now under the present procedures?
Under the present procedures, the region speaks with the employer and the union, and they negotiate, in most cases, a pre-election agreement. Well, in 86 to 90%
that's exactly what would happen now. They would try to negotiate an agreement. Let me get to the next issue, which you claim is so radical. And I don't know, maybe I'm wrong, but my understanding is in federal court, if I file a complaint, the defendant files an answer, the first thing the judge is to have a conference between the 2 sides where I say what my point of view is and my adversary says what his or her point of view is. The radical departure that you describe here requires the 2 sides to do the same thing. What's so radical about that? About the employer coming in and saying, here are my claims that I want to make in this hearing, and the union saying, here are claims I want to make in the hearing. What's so radical about that?
Congressman, you're an experienced litigator, I suspect, as I am. And as you know, litigators in civil court have an opportunity to develop their case. They have an opportunity to take discovery. There's nothing like that here.
Well, there's no opportunity within the pre-hearing to develop any other issues. You're completely res judicata barred from raising any other issues from your initial list. Is that your testimony?
The only issue that, or I say issue, is that all issues must be identified by the employer or they're waived. The employer can challenge employees during the course of the election, as can the union, even if they have not been challenged, or the eligibility has not been raised.
Thing that you talk about, the challenge to eligible voters. If you're concerned about that, then everyone sitting up here has the same problem, because in our elections we have what are called provisional voters, where someone goes in, they cast a provisional ballot, and if their vote would make a difference in the outcome of the election, you litigate over whether the vote counts or not. What's so radical about that?
Does that save time and money? I don't think it does. There's been the
Question is whether it's
suggestion that it
radical.
does.
Is it radical?
It is radical because currently regional directors have the discretion.
Well,
they exercise their discretion. Excuse me if I can finish.
Asked and answered. The gentleman's
Then,
time
Chairman, you
has
have
expired.
435 radically elected members of the House of Representatives, if that's the case.